Welcome back, legal eagles and believers in true justice. I'm your host, and tonight we are driving an entire fleet of truth right through the judicial twilight zone. For bizarre lawsuits in US history, Part 3. Tonight, we've got offended burglars who needed better escape routes, dogs whose barks are classified as Class A weapons, an environmental hazard that cost a city $6 million, and the ultimate, most common betrayal in the modern world, the great burger deception. Prepare to question everything you thought you knew about liability, common sense, and the financial cost of a disappointing lunch. Let's do it. Our first case is near and dear to every person who has ever looked from the laminated menu board to the tray in their hands and whispered, "What did I do to deserve this?" I'm talking about the lawsuit that targeted the sheer, unadulterated lie of fast food advertising, the catfish burger. This just happened in 2023. A group of savvy but deeply disappointed plaintiffs filed a class action lawsuit against fast food giants including McDonald's, Wendy's, and Burger King. Their claim was beautifully simple: false advertising. They argued that the burgers in the ads are 15% to 20% larger, taller, and fuller than the sad, deflated post-apocalyptic reality you actually receive at the window. This wasn't some minor complaint about minor details over a misplaced sesame seed. They brought an expert witness and forensic food photographers. They showed the glossy ad, a Big Mac looking like a glorious, multi-tiered wedding cake perfectly caramelized, lettuce stacked like an edible skyscraper, cheese dripping with structural integrity. Then they showed the reality: a burger that looks like it lost a fight with a tired child and was then slapped down by an uninterested employee. The ad promised me a 6-foot-tall, muscular GQ model of a burger. And what did I get? I got a sloggy 3-foot guy who listed his height as 6 feet on his dating profile. The emotional trauma. This is not food. This is food deception. They even went into the dark arts of food photography in court. They exposed the tricks. They explained how cotton balls soaked in water are used to generate that perfect fake steam. How motor oil is used on pancakes instead of syrup because it photographs better. How they use toothpicks and skewers to build the burger's height, like a support structure, only to remove them before you get your order. The food you saw in the ad literally couldn't exist under the laws of gravity and temperature. Now, you might scoff. Well, duh, it's an ad. But the judge, U.S. District Judge Hector Gonzalez in New York, actually allowed the class action lawsuit to proceed. The court basically said, you know what? This unfair difference between expectation and reality, this level of visual exaggeration, may be going beyond reasonable marketing, bragging, and crossing the line into deliberate, systematic fraud. This decision is a monumental victory for every person who has ever opened a fast food box and been hit with the gut punch of disappointment. It means that deep down, the court agrees. We deserve the burger we were promised. This case is a warning shot to every food company that engages in this kind of catfish marketing. The consumer is awake. They are armed with rulers and they are ready to sue for the height of their bun. Next up, we move from the crime of visual misrepresentation to the actual literal crime of breaking and entering. This is the case that became the gold standard for judicial absurdity. The upset burglar who sued victims for inconvenience. Back in 1998, in the suburbs of Pennsylvania, a gentleman named Robert was attempting a classic low-stakes break-in. He slipped into the garage, a rookie mistake. While he was busy searching through the family's stored goods, the automatic electric garage door closed. Robert, who apparently only specialized in entry and not exit, couldn't figure out the manual release. The problem? The homeowners were halfway across the world on a much-needed vacation. Robert was trapped in that garage for a horrifying 8 days. 8 days! No food, no water, no TV. Forced to contemplate his life choices while surrounded by holiday decorations, old tires, and the ambient noise of a continuously running hot water heater. It's an American horror story. When the homeowners returned, they opened the garage and there was Robert, exhausted, dehydrated, severely traumatized, and promptly arrested. You think the story ends there, right? Robert goes to jail for breaking in. Wrong. Robert sued the homeowners. The audacity, the sheer bold rudeness. His claim? Negligence and emotional trauma. He argued that the homeowners were legally negligent for leaving their garage door mechanism confusingly designed, effectively turning their property into a de facto jail without providing proper amenities, causing him severe emotional distress during his unexpected 8-day all-inclusive confinement. My client suffered. He was forced to survive on nothing. He endured the existential horror of realizing he couldn't open a basic door. The homeowners failed in their duty to care to ensure the safety of anyone who might happen to break into their property. The homeowners, bless their hearts, wanted to fight this insane claim on principle. But here's the crucial legal detail. Their insurance company, the ones with the deep pockets, said, "Wait, fighting this case could cost us millions in legal fees, jury expenses, and appeals. Settling is the cheap option." And so, to avoid an extended legal battle, the insurance company agreed to a settlement. The total? $500,000. $500,000 for the guy who broke in. Folks, this is the ultimate, definitive punchline of the American legal system. America, where even your burglar has rights and can get paid for a workplace injury. The moral is clear. If you're getting to be a criminal, don't bother stealing the TV. Just sue the homeowner for the poor working conditions. Moving from structural negligence to noise attack, our third case proves that sometimes your neighbor's pet is not just a nuisance. It's a fully operational high-decibel weapon of mass disruption. This is a case where a man successfully sued his neighbor for the mental trauma caused by their barking dog. The plaintiff here didn't just have a dog next door that barked occasionally. He claimed this was a systematic, non-stop, 24/7 siege on his peace of mind. The dog's relentless vocalizations at all hours caused him severe insomnia, anxiety, and a genuine breakdown in his mental health. The case was argued brilliantly. The lawyer didn't argue noise pollution. He argued wrongful infliction of emotional distress. The angle was, this wasn't just barking, this was psychological warfare. They presented evidence, hours of audio recordings, decibel readings, and doctors' notes confining the neighbor was effectively suffering from auditory drowning torture. They probably had a terrifying chart showing the spike in the Basset Hound's frequency response precisely at 3:17 a.m. The argument was that the dog owner knew the dog was this disruptive, yet did nothing to mitigate the nuisance, making the owner complicit in the psychological torment. This wasn't just a pet, it was a loud four-legged instrument of torture aimed at the plaintiff's bedroom window. And the result? The jury sided with the tormented neighbor, awarding him a shocking $500,000 in damages. $500,000 for being forced to listen to a dog. This case sets a staggering precedent. It says that your dog's vocal cords are legally liable. It confirms that you can and perhaps should hold your neighbors financially responsible for the noise coming from their property, be it a dog, a leaf blower, or a teenager practicing the tuba. The next time you hear a persistent bark, don't call animal control. Call your lawyer. Your noise complaint just became a legitimate investment strategy. Finally, we conclude with a case that reminds us that danger doesn't just lurk in confusing garages or squashed sandwiches. It also falls from the sky. The case of the woman who sued the city for slipping on pigeon poop. This incident took place in the heart of New York City. A woman was walking down the street when she tragically slipped and fell on a large, slick and accumulated patch of pigeon droppings, resulting in a severely broken knee. She sued the city for negligence. Now, a slip and fall is common, but the source of the hazard is what makes this legend. The argument was that the city had been grossly negligent in maintaining the public walkway, allowing a chronic, hazardous accumulation of bird waste to exist. It wasn't a single spot, it was an entire frozen pond for bird poops. A massive, slick, white patch of biological fallout under a popular overpass. The lawyer's angle was simple. The city has a duty to clean its sidewalks. Whether it's spilled coffee or massive piles of bird poop, a failure to remove a clear hazard is a breach of duty. This wasn't a fleeting hazard. It was a known, permanent hazard created by the city's inability to manage its feathered population. The case was hard fought, but the jury agreed that the city had failed its basic duties. The result? A stunning astronomical $6 million settlement. $6 million for a fall caused by nature's messiest, most opportunistic creature. That's $6 million that essentially came down to the price of cleaning a sidewalk. The supreme irony, of course, is that the ultimate perpetrator was a pigeon. The animal that caused $6 million worth of damages suffered zero consequences. The pigeon didn't show up to court because you can't serve a subpoena on a bird. It was probably off celebrating its legal victory by performing similar acts of sidewalk sabotage elsewhere. That pigeon is the ultimate, unindictable anarchist of the skies and a costly lesson for the city maintenance departments everywhere. And that, my friends, concludes part 3 of our tour through the truly bizarre corners of the court system. From the catfish burger that looked too good to be true, to the burglar who became a millionaire, to the dog that weaponized his bark, to the pigeon that broke the bank. Don't forget to like, subscribe, and tell us in the comments which one of these settlements you find the most criminally insane. We'll see you next time.